Just tell me what your names are so I can see who's missing. You are?
My name is Nancy Davis.
Okay, you're Miss Davis, and you are?
Kaitlyn Joshua.
Okay, and so we have no Vera Chapman Seals? All right, thank you. Yes, ma'am. Yes, ma'am.
Good morning. I'm going to go ahead and jump into it since I only have 3 minutes. My name is Nancy Davis. My significant other and I have 3 children, and we live here in Baton Rouge, Louisiana. In August of 2022, my family and I had a very life-altering experience. When I was 10 weeks pregnant, I received devastating news about our much-wanted pregnancy. Our baby was diagnosed with acrania. Acrania is a rare and fatal condition in which the skull and brain does not develop properly. We were told if I continued to carry, the baby would develop spina bifida, causing the head to get smaller, tucking back inside of its body, and a huge hole would develop on the spinal cord. He said my baby would die within minutes, if not at birth, and recommended we terminate the pregnancy to avoid physical and further emotional trauma. We were heartbroken, but we made an incredibly difficult decision after thorough research to terminate my pregnancy. To make a painful story short, we were denied a termination because healthcare providers, people trained and trusted to do their jobs, were afraid of prosecution and losing their license. At that moment, I knew I was being forced to carry my baby, to bury my baby. While still grieving, I had to navigate 1,400 miles to a foreign place, leaving my children and family behind just to access abortion care. I hope you can feel how dehumanizing it is to have autonomy over your own body taken from you. Every day that passed pushed me further into pregnancy, depression, and deepened the pain, but I was determined to reclaim my power. Healthcare providers reserve the right to give us the health care that we need and that we deserve. Physicians should be operating with the strength and trust of their government behind them. Being worried about losing their job or being prosecuted or fined does not put them there. Please know I am not alone in my story, and we must work to make sure this does not continue to happen. Although I am upset, as so many women in Louisiana are, about the laws currently as they stand, I come before you today, not out of anger, not out of rage, but I come to you and ask that you have a heart, have sympathy, have empathy, and step outside of yourself for 1 minute and try to envision what it's been like for women in Louisiana. Please pass House Bill 522. Thank you.
Thank you. Yes, ma'am.
Kaitlyn Joshua. So I'm here to tell my personal story, similar to Nancy's experience, and this idea that women are not being turned away from hospitals is absolutely false. We are two just examples of unintended consequences of the abortion ban. I've shared this story with CBS 60 Minutes, NPR, ACLU, and I will continue sharing that story until something has changed in our state. If you have not heard my story, I'm going to try and keep it short for the sake of time. But my husband and I were expecting last year. We at the time we had a 3-year-old. She's 4 now, and we kind of thought it was perfect to space them out in that way. I called my OB-GYN's office, was denied. I was told that I need to wait till 12 weeks, 3 months pregnant to be seen. I did not want to accept that answer, so I went to another facility, was told the same thing. So I kind of just went back to my original physician's office and said, okay, I'll just be seen here. Around 11 weeks, almost 12 weeks, just shy of 12 weeks rather, started experiencing miscarriage symptoms. I went to a hospital in Baton Rouge and was sent home with prayers after doing ultrasound, typical standard checks, vitals, etc. Was told that my baby's fetus had been deemed non-viable, and was measuring around 5-6 weeks instead of 10, 11, almost 12 weeks. Went to another hospital 2 days later with excruciating pain, likened it to can't even explain it. It was excruciating, it was humiliating, and I was told in that moment by a physician that it just looked like a cyst. She wouldn't have a conversation beyond that. She wouldn't speak to my mom, wouldn't speak to me, wouldn't speak to my husband, and all in all, ended up leaving that hospital until later that week, finally met a midwife who gave me Tylenol and told me to watch myself, etc. There is no way at almost 3 months pregnant I should have been turned away from any hospital, and this is something, again, that's happening numerous times daily in Louisiana. Nancy and myself have had women reach out to us from across the state who have had just crazy experiences and are looking to this legislative session to clear that up. Let's give physicians and medical professionals the ability to use their own discretion and their own determination around medical emergencies such as miscarriages. No one should operate in fear of criminalization, and helping anyone like myself, like Nancy, like others that are experiencing this. And I ask for favorable passage of HB 522 today.
Thank you. Yes, ma'am.
All right, my name is Leslie Palmer-Lee. I'm a board-certified emergency medicine physician. I'm here today testifying in my personal capacity as a physician and not on behalf of any entity. I urge you to support House Bill 522. Current law exacerbates barriers to timely and appropriate care by threatening to jail doctors for misinterpreting or incorrectly applying restrictive and confusing laws that are not grounded in the realities of medical practice. Fear that a non-medical entity such as law enforcement would later misinterpret our actions is causing dangerous conditions for patients. My colleagues and I should not be afraid that we could go to jail or be fined up to $200,000 for simply doing our jobs. House Bill 522 would address these harms by at least eliminating the possibility of jail time and reducing the excessive criminal fines. Current law jeopardizes the health and well-being of both patients and the medical community. This is not about people willingly violating the law or looking for loopholes. Physicians should never be in a position where we must weigh whether to delay or withhold necessary and sometimes life-saving care out of fear we could later be imprisoned for our medical decisions. House Bill 522 proposes another important change. The current stipulation that 2 physicians are required to certify a medically futile pregnancy in order to provide care under that exception is both antithetical to the usual practice of medicine and in many cases logistically impossible. Emergency care is provided by a single attending physician who is responsible for understanding all pertinent information about the case and performing medical decision-making based on established standards of care and the unique situation of the patient. It is dangerous and unreasonable to expect a physician that is not directly responsible for a patient to participate in medical decision-making. Furthermore, in many Louisiana hospitals, emergency medicine physicians practice as single coverage providers, meaning that they are the only physician in the ER and often the only physician in the entire hospital. Even if an ER doctor were to attempt to find a second physician outside the hospital, for many doctors, there's literally no one to call. As you all know, 1/3 of Louisiana parishes have no obstetricians. As an academic physician, I train tomorrow's emergency medicine physicians. Today's young doctors tell me they are apprehensive about staying in Louisiana to practice medicine because of these laws. We can't afford to have decreased access to health care, particularly in our rural parishes. I don't think any of us want to live in a community where the doctors caring for our loved ones are paralyzed by fear and confusion. We certainly don't want to live in a community that has lost all of its physicians because they don't feel they can care for their patients. Thank you for your time.
Thank you. And then I had Angelique Friel. Is Angelique Friel present or not? Okay, no. Oh, I'm sorry. You're.
Good afternoon. My name is Angelique Friel. I'm with the Louisiana Department of Justice, the Attorney General's Office. As you know, one of the duties of the Attorney General's Office is to defend the constitutionality of laws. And there have been challenges over the years related to abortion laws. And as it relates to this specific change, we have a proposed bill that would amend provisions in Title 14 as well as Title 40. It moderately relaxes state abortion laws in several respects, changes medically futile exception to abortion definition to require 1 doctor instead of 2, eliminates jail time and reduces fines, removes other penalties, and also amends language of the abortion definition We've heard some testimony that perhaps this legislation is needed to clear up existing law, and it's our position that that's not accurate. We think that the law is clear. It has been for many years. Louisiana has legislated relative to abortion since the 1800s. Last session, you had some comprehensive legislation to deal with this issue after a leak from Dobbs occurred with the United States Supreme Court. And so we have some concerns that this particular bill is not necessary, that the law is clear, that prior to the decision by the U.S. Supreme Court, OBGYNs and other medical professionals were able to execute this law. The law defines what is an abortion, what is not an abortion. There are situations that that this body has determined would be appropriate to necessitate the two medical professional certifications. That's a policy decision for this body to make.
So are there any other situations that you were aware of that you have to have two qualified physicians before the doctor can use their medical judgment?
I think that in this particular case, Representative, Louisiana's policy is that there is no constitutional right to abortion. And so the laws that are enacted are to preserve life.
Yeah, I understand, but the question was, are there any other circumstances that you're aware of where two doctors are required to give to give a medical certified judgment before they can proceed?
I can research that issue. I'm not here to testify about that. I'm here to testify
I'm not sure that
relative to
you're here
abortion.
as a white card. It sounds like you're here in opposition, but that's
Well, I'm
neither
here
here
to-
nor there.
I'm here to just provide information because we are actively defending the state in cases. And it's our position that this law is not ambiguous and it's not needed.
And also, right, that's a red card. And also, are there any other situations in the law that you're aware of where a doctor can be faced with a criminal penalty for making a decision?
Sure, absolutely.
Which ones?
If a doctor does something that is against the law, then absolutely, there are criminal penalties that are imposed. You need to look at the law relative to the definition of abortion. And by law, an abortion is not the removal of an unborn child who is deemed to be medically futile. It just requires a diagnosis of two qualified physicians. And what we have seen is surveys of abortion clinics in Louisiana where some of the individuals that are employed are not the most qualified. You have ultrasound technicians that one in particular had no experience other than took pictures in a photo lab. And so there are reasons why this body has made policies, decisions, why it would be appropriate to have a certification required by two qualified physicians. These laws arguably are here based on what you all have decided is the policy consideration that's important to Louisiana voters. And so we think this creates ambiguity. Our Solicitor General, Elizabeth Murrill, had hoped to be here. She had a conflict. She's the one who's most familiar actively defending the state's laws relative to abortion. It's possible she may come in a few minutes and provide some additional information.
All right, Rep. Marcel.
I would just like to withdraw my motion.
And Chairman, to your point, it is a white card, but if you think otherwise, I am the Director of the Civil Division, and I am designated to make the position of the Attorney General, Jeff Landry.
All right, I understand, but when you fill out a card, you're either in support or opposition or neutral and here to just answer questions, and everything that I've heard you say is nothing close to a white card.
Well, you asked me questions. I basically came up here to tell you that the law as it stands, we have argued that it's clear,
Right.
and you asked me very pointed questions.
All right, well, we don't have to debate the color of the card anymore. I'm sorry about that. The board is clear.